this morning's docket in the matter of Brian R. Johnson.
May it please the court, Kate Baird, Deputy Disciplinary Administrator, appears for the Disciplinary Administrator's Office. Mr. Chief Justice, may I reserve 2 minutes for rebuttal, please?
2 minutes is granted.
Thank you. Justices, respondent, may it please the court. This original action in discipline is before the court after a panel hearing considered evidence in October of 2013 and issued a report, its report, in March of 2014, making findings of fact and conclusions of law. The respondent did not take exception to that hearing report, to either the findings of fact or the conclusions of law. So the matters before the court largely on the question of sanction. There may be members of the court that have some recollection of the respondent and I appearing here not too long ago in the spring of 2012 on an earlier disciplinary action. As a result of that conduct, this court ordered in May of 2012 that the respondent's license be suspended for a definite period of 1 year. In its order, the court directed that the respondent comply with Supreme Court Rule 218. In July of 2012, our office was notified by a district court judge that it appeared that the respondent had failed to comply with the court's order directing that he provide written notice to clients and to the court that he was no longer able to represent clients and would need to withdraw. That resulted in a disciplinary complaint being filed and investigated in our office. 2 other complaints followed. I'll note that those 2 subsequent complaints, one filed in August and one filed in March of 2013, reported conduct that largely occurred prior to his suspension. So the conduct that the panel considered occurred prior to the May 18, 2012 suspension, largely, not exclusively. There was some concern about the respondent's conduct with regard to his client, Dr. Rothschild, after his suspension. The panel considered the evidence, as I noted in October. They considered stipulations offered by the respondent, and they concluded that the respondent's conduct in the 3 matters violated KRPC 1.2, 1.4, 1.16 concerning obligations concerning the termination of representation, 8.4C, 8.4D, and finally Supreme Court Rules 211 and 218. As noted earlier, the respondent did not take exception to those findings and conclusions. The panel recommended unanimously that the respondent be indefinitely suspended. I'll point out also to the court that in the report, the panel referred to standards that demonstrated that they considered both disbarment and suspension as they deliberated the appropriate sanction. I'll repeat to this court what I told the panel in preparing for the hearing and going through that disciplinary process with regard to the respondent. In light of his conduct, in light of his disciplinary history, it was my impression that disbarment had to be in the conversation, in any conversation regarding sanction. I ultimately recommended indefinite suspension, and the panel unanimously made that recommendation also.
Excuse me, counsel, the panel made reference to the beginning of a personal transformation to support its choice between disbarment and indefinite suspension. Could you share with us what that relates to, if you know?
I would suspect, and I will respond by saying I noticed that also. and I agreed with that representation in the report, that there was a perception of the seeds, the beginning of a personal change and personal and professional change. I would suspect that it had to do with his stipulations, in part to the facts, to his indication that it was not necessary to bring in to cause the complainants, Judge Kittle, other complainants into the proceeding, that he was not denying that his conduct violated the rules of professional conduct. There was also testimony at the hearing that that appeared to suggest that, having been removed from the practice and looking at his conduct in retrospect, that there was a different perspective concerning his behavior when he was licensed. I don't know if that answers your question, Justice Breyer, or not.
I'm sure it's the best you can do. I'm more interested in kind of specifics, if you have them, other than just sort of a general perception on your part or on the part of the panel members. Were there specific steps he had taken, or other than stipulating?
Not that I can point out to, other than what was represented in his demeanor, in his tone, and his observations that were at least articulated to the panel at the time.
Okay, thanks.
And he may be able to offer
Right.
comment on that.
I'll inquire with
also.
him as well.
And that does actually lead me to the factors that I considered in making that recommendation, because I think everyone would, I suspect there'd be an agreement that disbarment is an option that had to be considered. I considered that factor, as did the panel. There was an apparent change in demeanor and an acknowledgement that the conduct was not consistent with our rules. I thought that was relevant. That was a relevant factor in making that recommendation. The panel pointed out that there did not appear to be evidence of personal gain as a result of the respondent's conduct. And finally, as a very practical matter, when I looked at the time frame within which we were putting this conduct and the suspension in context, in this hearing in October of 2013, the respondent's license had been subject to disciplinary sanction since May of 2012 for about 17 months. In the event the court orders an indefinite suspension today, he will not be eligible to petition for reinstatement until, at the very soonest, September of 2017, which is beyond 5 years from the time of the conduct, or the most of the conduct that we're talking about, which would have been equivalent to a disbarment back in May of 2012.
And is that your recommendation to us today?
I'm sorry, I didn't mean to interrupt you.
The indefinite suspension that the panel imposed, or do you have a different recommendation?
My recommendation today remains the same. I recommend that the court consider the timing, the effect of an order of indefinite suspension will remove this respondent from the practice of law by reason of disciplinary sanction for at least 5 years. Of course, he would have to, if he elects to petition for reinstatement, demonstrate that what the panel perceived as to be the seeds of change has continued, has developed, and at a reinstatement hearing, certainly I would expect that to be explored. But I would, unless there are other questions, I would renew my recommendation that was made to the panel and ask the court indefinitely suspend the respondent for his conduct that was demonstrated.
The conduct that gives rise to why we're here today took place before the 5/18/12 suspension.
Most of it.
Most of it.
There was, I'm sorry.
No, that's fine, most of it, but then there was some conduct that's after, in that there was some concern that he didn't communicate to his clients
Right.
the 5/18/12 suspension.
Yes.
So it's kind of both. We have
Related.
two, okay,
At or near the time of the May 18th suspension.
right, okay.
Any more questions? Thank you, counsel.
Thank you. Mr. Johnson, thank you.
Good day, Chief Justice, members of the court. I have to first say that I apologize for my conduct, particularly to the clients who are truly victims based on my conduct. I think even before the time that led to the first suspension, I don't think I was clearly articulating that to this court. Also, I want to state the disrespect that I obviously have shown to the bar and to this court by my conduct. I think that the symptoms of my attitude were on display with these sanctions that I've received by this court. I think after the time that I was supposed to notify my clients, I was not real happy. So I had to really think about who I was, what I was doing, and how I felt about the law. Well, I think that for a time that I did disrespect the law, and actually, I think I have to be honest with myself. I saw myself through eyes that I would rather not have. I think the perception of being a lawyer, perception of what was expected, the perception of what I thought I needed to do to be accepted in the practice of law was skewed. I think back that while I'm here today, I had a pretty doggone good career. My first job was working with Chuck Simmons at the Department of Corrections, who is, I think this court will know, is a fine man, fine lawyer. The next lawyer I worked with, Brian Moline, who likewise at the KCC, fantastic. They taught me a lot to learn, to be a lawyer. The third was Randy Rathbun at the U.S. Attorney's Office, okay? And then finally, working with, at the Attorney General's office with John Campbell. Now, I think you'd be hard-pressed to say that I hadn't had enough opportunities to learn how to practice law and how to respect people. So my problem I had to look at really came through with the fact that I just felt personally disrespected at times by what I perceived. What do I know now? I was not. That was my baggage and the way that I perceived life as a lawyer. I think sometimes I had no business going into private practice on my own without a net. I worked with good men, but I think I could have been schooled up a little bit better. So since I've not been practicing law, I've gone into something that I think has really given me ability to think through and really kind of reach out and provide the type of service to my clients that I'm doing now. I'm presently working as a house manager with disabled, intellectually disabled adults. And so the one thing I always jam down the throats of my employees is that we need to provide for the health, safety, and welfare of these people. And that to do anything less, then we're failing them, their relatives, and actually a lot of people in the community, because they too have the same responsibility for these gentlemen who happen to live with us today. So not only have I learned how to be selfless, not selfish, that's been a boon. So if I left here today and was not able to stand in front of these lecterns again, I'd be still fulfilled. I would understand your decision, and would take it like a man, understand the thing important to you all is that the public safety be maintained. I can tell you today that not only has that interaction been fruitful, but the other interactions, there's a lot of people that care about these gentlemen that have their own interest in them. I've learned not to be dismissive of them. It's important for me to accept other people's viewpoints and not dismiss them. I think as an attorney, I've got a little sharp, and I think that even with clients, I think that I would not necessarily listen to them. I think they became a mode of financial gain. I think it's sad when you get excited as a lawyer. Here's a client comes in, personal injury, and their livelihood is destroyed, their family structure is destroyed, and you're happy because you get a personal injury case that could gain you money. That was my mindset. Okay, did I provide personal support for those people? Yeah, but how good is that if what you're doing is, I'm glad I'm gonna get some money. Okay, well, I'm not there now, and I shouldn't have been there, and no one taught me to be there. Okay, I'm not blaming anybody. That's the hole I fell into. And so with the people that I have to deal with, I'm learning to deal with them in a much more patient tone. Something I think there probably could be a line of secretaries that I've worked with that would say the same thing and wish that I'd have shown a patient tone to them. So what I'm saying is this. I would like to have an opportunity to prove to this court and to the public that Brian is ready to practice law again. I'm coming from a totally different perspective on what I need to do to provide services to the public. I benefit from a great family with a great structure and learned a lot from them. And I now know that I've got to represent them. I've got to represent my clients. I got to represent my boys at the home that I supervise. And whether I leave here or not, with in the future, 3 years or 5 years, I can tell you that I'm prepared to uphold my end of the bargain and represent the state of Kansas, my clients, to the best of my ability.
Was this a realization that progressed over time, or was it just an epiphany and one day you say, I see I don't want to follow that path anymore? Do you know?
I think it's a realization that you can't place blame. You got to look at yourself. I think that I've taken a tack that even if my computer goes out, I'm going to take responsibility, rather than yelling at it or anything. But I think it was more working with the fellas. I have a great deal of responsibilities. I clean the toilets, I cook their meals, I do any number of things. And they're not so much as you could call, can't think of the word, but it helped the realization that there's bigger things out there, that it's better for you to feel good about yourself. I can't tell you, physically and mentally, I've never been better. Okay. And I think that part of it, of course, when I went to this court before, it was a slap in the face. Okay. I'm not going to say I walked out of here all jubilant. And when I got the letter saying I was going to be shut down for a year, then though I was mad. Okay. And it wasn't until after I started working with the fellas that I had to do a self-realization and identify what is my, what in the world. Like I said, I went through, this court can see Indian litigation that I was involved in, the Winnebago trial out of the Attorney General's office. Heck, while I was being suspended pending that, a case came down that I prevailed in, the Bear case that tried to outline the jurisdiction for district courts over Indian reservations. I think that's still standing. They tried to come up here and do a petition for review, and then shortly before I came to you myself, they struck, you did not accept it. So it's law. But the point being is, it was over time, but then there was that immediate gratification that I got working with the fellas. That was pretty much it.
And before you sit down, can you tell us what you would like for us to do about your situation?
I would like to get my license back sooner than later for one reason. I think for this court to just take my word for it as I sit here would be a little bit naive of me. I don't want to do that. I want to put you in that spot. I would be glad to have someone overview what I do as a lawyer. If a suspension, I'd like to. That's fine. But any attempt to get the license back after that suspension, I think it would be fair enough to have some type of supervision. But I got to tell you, I enjoy the job I have now, also. And so that's not, if I were to be reinstated tomorrow, I wouldn't leave the job I have.
Very good, thank you. Anybody have any questions of council? Any further presentation?
No, sir, thank
All
you.
right, thank you. You're reserved 2 minutes for rebuttal.
Reserve 2 minutes, Mr. Chief Justice, unless the courts, the justices have questions, I would waive that.
Any questions? I see none. Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. That